According According to Black Law Dictionary, foreign non-convenience refers to the discretionary power of the court to decline jurisdiction when convenience of the party and the end of justice would be better served if action were to be brought somewhere else. In England, the idea of foreign non-convenience was largely limited until the year 1973, when the House of Lords changed its position in the case of the Atlantic Star 1974, but the doctrine was still unclear for a period. Only in Lord Gore's influential speech in the case of Splendor Maritime Corporation and Cancellex Limited 1987, that the doctrine of foreign non-convenience was finally recognized as the basis of granting stays of proceedings brought during the defendant's presence. Lord Gore laid out several fundamental principles in the case of Splendor, including that a stay would only be granted on the basis of forum non-convenience if the court is satisfied that there is some other available forum having competent jurisdiction which is the appropriate forum. If the court is satisfied, the plaintiff would then have to demonstrate why the interests of the parties and the end of justice require the trial to be held in the original forum. Factors were relevant in accessing the stay application, including the place which had the most real or substantial connection to the action, the availability of the witnesses, the governing law, the places where the party live or carry out their business, and the fact that the plaintiff will not obtain justice. This was reaffirmed in the most recent case of VTB Capital and Nutritech International, where the refusal of leave to serve out of jurisdiction based on foreign non-convenience ground is another means for the court to determine jurisdiction, as it allows them to determine if the proceedings filed elsewhere are more appropriate due to connecting factors.
Based on the forum non-convenience doctrine, courts can exercise its discretion to stay proceedings or refuse leave for service out of jurisdiction, and per Lord Gore again in Spiliada, an appeal against a court's discretion should be rare, and the appellate court should be slow to interfere. This helps achieve some legal certainty. Based on the forum non-convenience doctrine, courts can exercise its discretion to stay proceedings or refuse leave for service out of jurisdiction, and per Lord Gore again in Spiliada, an appeal against a court's discretion should be rare, and the appellate court should be slow to interfere. This helps achieve some legal certainty. However, the forum non-convenience approach clashes with the principle of lis alibi pendens that is predominantly applied in European civil law jurisdictions, under which a court second seized of a dispute must decline jurisdiction in favor of the court first seized. After the United Kingdom became a key cog in the economic development of the common market of the EU and acceded to the Brussels Convention in 1978, this coordination extended to judicial cooperation to make the approach to determine jurisdiction uniform Europe-wide. Owusu and Jackson tells us that Article 2 of the old 1968 Brussels Convention provides that persons domiciled in a contracting state shall, whatever their nationality, be sued in the courts of that state. Thus, where a defendant is domiciled within a contracting state such as the United Kingdom, there is no room for an English court to decline jurisdiction by staying proceedings on the grounds of forum non-convenience. Jurisdiction in cross-border cases pre-Brexit is primarily governed by the Civil Jurisdiction and Judgments Act 1982, which gave effect in English domestic law to the 1968 Brussels Convention. The Council Regulation number 44 of 2001 of 22nd December 2000 on jurisdiction and recognition and enforcement of judgments in civil and commercial matters, however, has been superseded by Regulation number 1215 of 2012, or more commonly known as the Brussels Recast Regulation. Articles 24 and 25 of the Convention is in most ways in line with the common law approach to determining exclusive jurisdiction, irregardless of the domicile of the parties, by looking at the stronger connecting factors such as the place of performance of a contract or the choice of the parties. Article 29, Clause 1 of the Brussels I recast provides that if proceedings involving the same cause of action and between the same parties are brought in the courts of different member states, any court other than the court first seized shall be obliged to stay proceedings until such time as the jurisdiction of the court first seized is established. The lis alibi pendens principle in Article 29, Clause 3 makes jurisdiction mechanical, and as such, a court exercises no discretion in that where the jurisdiction of the court first seized has been established, any court other than the court first seized shall decline jurisdiction in favor of that court. The previously mentioned conventions in most ways has suppressed the forum non-convenience doctrine, as the guidelines in the conventions are in place to harmonize jurisdictional questions throughout the EU. Thus, the step-by-step approach in the lis alibi pendens doctrine whilst clinical and structured can be said to be more predictable for the party suit.
Hi Miss, so today I'll be explaining further about the doctrine of forum non-convenience. So the true purpose of the conventions is to discourage forum shopping by harmonizing the jurisdictional roles of the contracting states. The claimant will probably sue another wherever they will be in a more advantageous state. For instance, England, which are seen to be more generous in awarding a successful claimant. However, Ian Gordon wonders from his article that if an English court can grant a stay in favour of the courts of a non-contracting state in circumstances where it considers that the dispute can be more appropriately heard there. As the United Kingdom, pre-Brexit was a signatory state to the relevant conventions on jurisdiction. It made sense amongst fellow contracting states to apply this regimented approach in establishing jurisdiction. However, the clarifications in Owusu against Jackson that the conventions, in particular the Brussels I recast, modified the forum non-convenience approach. So now, jurisdiction is seized rigidly based on the defendant's domicile, and this extends to even a non-contracting state being a more appropriate forum for the claimant to seek redress. Conversely, if a suit is brought in English courts against a defendant domiciled in another contracting state, the English court is deemed to have no jurisdiction and must stay the proceedings. Once the jurisdiction of the court is first seized has been established, any other court rather than the court first seized shall decline jurisdiction, per Article 29 subsection 3 of the Brussels I recast regulation. Therefore, from the Owusu against Jackson case, we can learn that if a defendant was domiciled in the United Kingdom, and even that if there was a more convenient forum in non-contracting states because there were stronger connecting factors to that jurisdiction, an English court is precluded from staying the proceedings in favour of allowing the claimant to file the proceedings in that convenient forum. The English courts must assume jurisdiction and hear the case, primarily based on the defendant's domicile, England. Per Qureshi, the case of Owusu against Jackson tells us that the doctrine of forum non-convenience may only be applied by the English courts in matters falling outside the scope of the Brussels regulation, or in matters in which all defendants are domiciled outside of the European Union. The 2007 Lugano Convention was incorporated into the United Kingdom law by the Civil Jurisdiction and the Judgments Regulation 2009. The 2007 Lugano Convention applied to the UK during the UK and EU transition in the midst of Brexit on the 31st of December 2020, and is materially the same as the 2001 Brussels regulation as it governs the issues of jurisdiction and enforcement of judgment between the European Union member states, but extended this to the European Free Trade Association's countries as well. However, the Lugano Convention ceased to apply in the UK following the end of the transition period, except in relation to the proceedings commenced by that date.
I will now proceed to analyze the development of the doctrine and its application in other jurisdictions. One of the aims of the doctrine is to deter forum shopping, that is, the choosing of forum by the plaintiff based on the advantages in the proceedings rather than whether it possesses the objectively strongest connection in the case, and this chosen forum may be inconvenient, oppressive, or overly burdensome on the defendant. The doctrine therefore can be used to dismiss these claims, and as per Lord Reid in the Atlantic Star case, the plaintiff should be able to explain why they chose a particular forum for the suit when faced with a forum non-convenience request, a failure of which a stay would be granted. Judicial committee is another major justification to the doctrine, and this is illustrated in the case of Bhopal. So plaintiffs should not have unfettered discretion in choosing a forum, as it may offend a country's sovereignty when another country tries a case that is more intimately related to the former than the latter. Although one of the initial purposes of the doctrine was to deter forum shopping, it is actually counterproductive because it invites for reverse forum shopping by the defendant. This can be seen in the American case of Piper Aircraft Company, where the courts did not consider the adequacy of the alternative forums remedy as a factor to be balanced when deciding a forum non-convenience request. However, in the Canadian case of Club Resorts Limited, the Supreme Court declined to grant a stay because the defendants had had not met its burden of showing that the alternative forum was clearly more appropriate. This therefore shows that the doctrine is in fact not counterproductive, as it imposes a heavy burden on the defendant. The second limb in the two-folded test in Spiliada has been criticized to be unclear as to which factors are considered in the determination of concrete achievement and the maximization of the quality of justice to the parties. Lord Diplock has attempted to clarify in the Abedin-Dever case, but they do remain slightly obscure. In addition, the unclear nature of the second limb of the test is counterproductive to the initial purpose of the doctrine to minimize docket congestion, as it overburdens the court with factors and evidence to be considered. The doctrine is also wholly inconvenient as stated in the Spiliada case. It is inappropriately time-consuming and wasteful for the parties to have to litigate in order to determine where they shall litigate. The change of the doctrine from the abuse of process principle to the more appropriate forum approach, as illustrated in the Australian case of Voth, illustrates that the doctrine has been stretched beyond its purpose and that the courts now exercises a greater discretion since its development. This doctrine has applied in the United States, and this can be seen from the case of Sinochem International Company Limited, where it was held that the federal court may hear and pass a ruling on the forum non-convenience claim. However, in most states, the doctrine has not even been considered, while it has been rejected in others. As of today, the doctrine is applied in less than half a dozen courts in America. In Malaysia, on the other hand, it is clear that the doctrine still applies as of today, as illustrated in the more recent case of Alu Panorama Metals Sendirian Berhad against Okaya International Limited.
Good morning, Miss Xia. I'm Hizin, and now I'm going to talk about post-Brexit developments by the English court. Since Brexit, the Brussels I recast regulation no longer applies to the UK. The regulation overcomes the forum non-convenient doctrine by establishing the jurisdiction of the courts where the corporate defendant is domiciled. In April 2020, the UK applied to accede to the Lugano Convention, which contained a similar provision. However, the EU has recommended in mid-2021 to veto the UK's application. Not being able to accede to Lugano means losing a standardized EU-wide system, reverting to the regime before the UK entered the EU and allowing parties to foreign shop. Gawal says this uncertainty in jurisdiction revert to national law, thus facing a lengthy process for determining court competence and subsequent enforcement of the judgment, and significantly extending the timeline to the despair of the interest party. Regulation 4 of the Civil Jurisdiction and Judgment Regulation 2009 removed the effect of the Lugano, and the Civil Jurisdiction and Judgment Regulation 2019 effected the same as to the Brussels Convention, which came into force on exit day. Section 49 of the Civil Jurisdiction and Judgment Act 1982 provides that nothing in this act shall prevent any courts in the UK from staying, ceasing, striking out or dismissing any proceeding before it, on the ground of forum non-convenience or otherwise, where to do so is not inconsistent with the 2005 Hague Convention. In the case of Al Assan 2022, as the proceeding was served after the end of the transition period relating to the exit of the UK from the EU, the Brussels regulation recast no longer applied. As such, whether the Court of Serious were the most appropriate forum was to be decided on the basis of common law by applying the two limbs of Spiliada. The re-emergence of Spiliada is one consequence of the UK's departure from the EU. It starts from the proposition that English jurisdiction should not be declined unless that is a clearly most appropriate forum. By contrast with the Brussels regulations, it is substantially less internationalist in its outlook. Spiliada's re-emergence is likely to make forum challenges more difficult for a reluctant defendant, even in disputes that are truly international. While commercial parties may take comfort in the preservation of the status quo for choice of governing law clauses and the EU's accession to the Hague Convention on choice of court agreement, limitations and uncertainties have been introduced into matters of jurisdiction and enforcement of judgment in the EU. It remains to be seen whether the EU It remains to be seen whether the UK is able to accede to the Lugano Convention and resolve these issues. Even if the issues cannot be addressed in this way, it remains the case that the changes that have been taken place are not so fundamental as to call into question the many advantages offered by the UK courts as a forum to resolve cross-border disputes. Nevertheless, parties may wish to take the opportunity to consider whether the dispute resolution provision in their contracts in present and future are optimists for transactions involving EU parties. Thank you.
Forum non-convenience is well recognized under the law of administration of justice system, and it has replaced the ancient rule of lis alibi pendens in England. It can also be useful to remark that the doctrine of forum non-convenience does not originate from England, and that English law adopted it quite recently for practical exigency. This change has been welcomed in England by the majority of the judges and writers for the reason it could be considered an improvement under the civil law jurisdiction, giving them a possibility to find a more flexible approach without destroying the exigency of certainty and predictability.